Thank you. Good morning, everybody. Dear partners within the research groups, the research group, and esteemed guests, especially students. I'm really happy, especially for students. It is an honor for me to stand here again and to share with you the results of my part of this research within the research group. I'd like to thank the organizers, and especially I'd like to thank David, because some time ago I got a question whether I really theoretically deal with sovereignty as such. And I said yes, because most of the members of the research groups are within the EU law, and I am within, as for my research interests, I'm international law person. So this is gonna be something really theoretical, something really with general terms, not to disappoint you. I do with theoretical approach with sovereignty. So equality in an ever-integrating Europe in general terms. I'd like to thank also BATEC, because within our research group, as within any other research group, there are dissemination events, and I've been invited to participate within your dissemination event. And when I was thinking about, all right, because it is equality, and it is about sovereignty. So the title of my presentation there was Sovereignty as a Basis of Equality. As for today's plan, I'd like to look at the sovereignty as a driving force in international law through the lenses of the change of the perception of the state sovereignty. As everybody knows, we have already submitted a scientific article, so I'd like to present what the partial results of my research are. The outline of today's presentation, it is about sovereignty itself. I've looked at sovereignty from two perspectives. The first one is from inside out. It means how states themselves perceive and exercise their sovereignty, particularly through legal frameworks at national level. And I'll focus much more on the outside-in perspective. It means how external factors, including international organizations and the broader global community, influence and reshape the understanding of sovereignty. My claim is that the sovereignty as such has not changed for international law. It means that states still matter. I'm sorry for a grammatical mistake here. So states still matter. But maybe what I claim, the raison d'être of the states has changed. Yesterday, I was at one very interesting lecture of one professor, and he focused much more on the fact that what has changed, and that what the idea of international law, it is the well-being of individuals. What I'd like to focus on today, it is true, the sovereignty and the approach and manifestation of sovereignty has changed. Nevertheless, it is still the states that make the law, that create legal norms, and it is still the states that should think about pacta sunt servanda. So that was a little bit longer introduction. Thanks for the ring announcement. I'm pretty sure I'll keep the timeline. So traditionally, as we all know, because we've studied international law during our studies, it is absolute authority of a state to govern its affairs without any external interference. That's the principle of international law. That's the principle of UN Charter. We can read that almost in every document that it establishes international organization. This is traditionally a principle that was formulated and completed transformation of the development of the relations among states after the 30-year war within the Westphalian system in 17th century. Nevertheless, if we look at states and their sovereignty today, it is a different approach and different understanding, because currently the authority is understood and perceived as responsibility. You must have heard about the project of responsibility to protect, for example. So it is still sovereignty. The term is the same, But as lawyers, we know that interpretation matters. So nowadays, authority is perceived much more as responsibility. So states, yes, they are still sovereign, still equal. However, that theoretical approach of absolute independence and autonomy of sovereign states in 17th century, because of that switch of the Pope and the emperors into independent states, nowadays it is much more complex. And there's the nuanced concept of asymmetric interdependence. And that interdependence leads to a certain interconnectedness of states. It means, again, we still talk about sovereignty, but this sovereignty of states coexists with mutual dependence in a globalized world. And therefore, there's not only a desire, but a necessity for states to cooperate. And last theoretical slide, much more theoretical than the previous slides, because in my research I looked at how the concept of sovereignty from the territorial approach changed as well. And I, within my article, I presented three big thinkers, philosophers, Hobbes, Locke, and Rousseau. And these theoretical approaches, they focus on the territorial units. It means really how the sovereign ruled over the territory and persons within the territory. That's the original traditional concept of sovereignty. And at the beginning, Hobbes pointed out it's only the safety that the state offers, the sovereign offers to the population. As for second treatise on the government, it was a little bit more. And as for Rousseau, within the social contract, there is the notion of common good. It means not only individual relationship and guarantees of a state towards the individual needs of protection and safety, but the issue of common good. It means something what we call community nowadays. And that's why I've pointed out that it is true. The territorial approach and understanding of sovereignty changed from the 17th century. We understand what happened. We understand why it was important to support the establishment, existence of independent states because of the Pope approach and other ways of support of power within Europe. And that 17th approach actually took more than 300 years, and new states were created. And the approach was always the same. You need, and it is like nowadays, you do have Montevideo Convention. For a unit to be understood and perceived as a state, you need a territory, you need a population, you need an independent exercise of power. Nevertheless, because of the exploration of the globe, there is no other space to create new states. And there is no real independence, there is the interdependence. And it was formalized also through the decolonization after the Second World War and establishment of new states. And afterwards, since there is no more territory, the focus has changed, the understanding and the perception of sovereignty. As I said, the globalized world has created the issue and understanding of the international community as well. And how that is understood then within practical issues, of course, the focus is on individual. It is the human rights approach. It is the responsibility of a state. It is not the authority, I rule, I govern, l'état c'est moi. No, it is the individual that is the lens, the focus of the further development of international law. So that was the philosophical approach to understand that change of perception of state sovereignty. And to make it more practical, when we talk about manifestation of sovereign rights, you might laugh now when I say more practical, because I've looked into Wimbledon case, and that Wimbledon case the decision was adopted in 1923. So we might think like, more than 100 years ago. So what does that say? Wimbledon case was a very important case decided by the Permanent Court of International Justice, the judicial body of the League of Nations. And it was understood at that time that that was the level of sovereignty that I explained as the territorial approach and real like l'état-c'est-moi, absolute authority. But already 100 years ago, the court decided, yes, you are a sovereign. But if you ratify a treaty, you are bound by the treaty. As for the facts, it was a decision because Germany, being party to Versailles Treaty, afterwards declared a neutrality in relation to another smaller war, and said that could not or was not obliged to allow free passage through a channel, and declared that according to the international treaty, there was the duty to let the British vessel with French goods for enemy to one smaller war. But Germany said that no, we have declared neutrality and we are authorized not to let them go through the channel. And the court said that's individual act of declaration of neutrality towards let's call it bilateral war, but as for international order, you are a party to international convention and you are bound by the treaty saying that you are obliged to allow the ships go through the channel. And this is manifestation of your sovereign right. It was your right to become a party to the treaty, and as soon you are a party to the treaty, you cannot declare after some years that now we are neutral in relation to this relationship within other smaller war, let's go this way. No, you are still bound by your manifestation of sovereign rights to when becoming a party to the treaty. And that's what I think is important beginning of the transformation from the Westphalian, even before decolonization. When a state becomes a party to the treaty, it has to fulfill the obligations coming out from the treaty. So pacta sunt servanda did matter, still matter, and will matter. And as for the more specified issues within further research, I'd like to focus on that it is not only a principle for states, but also for international organizations established by those states. So as I've said, I'll keep the time limit. Thank you very much, even before the ring, for your attention. And I look forward to your comments, your experience, and expert questions. Thank you very much.